Our first triennial Baronial Order Magna Carta 800th Committee Symposium. It is indeed an honor to introduce our distinguished panel. And we have our moderator, Dr. Russell Miller, teaches at the Washington and Lee School of Law. Dr. Hamilton Bryson teaches at the University of Richmond School of Law. Unfortunately, one of our panelists has not arrived, I guess the traffic or something. We have Nicholas Ward, who is an attorney in private practice at the metropolitan DC area. So, gentlemen, if you want to step up on the podium there, and we'll begin our panel.
My area of research and my work is in American constitutional law, but primarily in comparative law. And that means that I work extensively with German constitutional law. And I was curious if Mark might have been aware of the numbers of German awareness of Magna Carta from this survey. Yeah, all right. I'd be curious. Germans, I suspect, would say that the strongest ties to Magna Carta are through the constitutional developments that are evident in this long chart that the Trust has developed, and that they've inherited the lessons of Magna Carta and the rule of law through the French Revolution and through the American constitutional experiment. But I have to say, I was left wondering, why am I the appropriate person to moderate a panel, considering this Teutonic expertise, to moderate a panel on Magna Carta with its rich English tradition? Well, I am certain that part of the answer to that is that we can expect me to keep proper time on the panel, which I intend to do with strict Teutonic order. It's also true, of course, that the Germans have loaned a few things to the English, even if they might not like to hear it. None the least the current Hanoverian royal family. But maybe the most important signal of the German relationship to the English is the oft-repeated quote in England about their cherished national game. Football to them, soccer to us. It's often said in England that soccer, football, is a quite simple game. The ball is round, you play for 90 minutes, and the Germans win. I want to join several others in thanking the organizers and hosts and sponsors. Most importantly, the Baronial Order of Magna Carta. But I also want to thank the UK government's Magna Carta Trust, represented by Mr. Gill today. We're extremely honored that he's made the trip to be with us. And I also want to extend our gratitude to the Cosmos Club for hosting us here today. With that, I want to turn to the symposium this morning. We're lucky to welcome three remarkable scholars for presentations on and discussions about the enduring meaning of Magna Carta. And I have to say, this is going to be a tough crowd to try to communicate the enduring meaning of Magna Carta, because of course you embody the enduring and legacy of Magna Carta. For me, let's be straight. For me, what that means is to stand for the legacy of the individual against authority. And we might choose to call that the rule of law and frame that in legal terms, perhaps even in the doctrinal terms of law that will emerge in the presentations today. But I think there's something more human about that. To inherit the legacy of Magna Carta, to embody the legacy of Magna Carta, is to inherit the legacy of the images each of us are very familiar with respect to the power of the individual against authority. It's impossible to capture the iconic image for each of us of that posture, but just to mention a couple. To inherit the legacy of Magna Carta is to inherit the legacy of a Chinese dissident student in Tiananmen Square. The individual against authority. It's to imagine solidarity in the shipyards, clinging to the fences in the face of martial law. And yes, even as was mentioned by Mr. Gill, a young schoolgirl insisting on attending school. With that, I want to welcome our guests. We have with us today William Hamilton Bryson from the Richmond School of Law, where he teaches English and Virginia legal history. We're lucky to be joined by a representative of the order, Nicholas Donald Ward, a lawyer in practice, having argued before the Supreme Court of the United States and invoking in those arguments Magna Carta. And then we'll hear from Joyce Malcolm, the Patrick Henry Professor of Constitutional Law and the Second Amendment at George Mason School of Law. I'm going to return to the dais and then ask that we begin with Professor Bryson.
Thank you very much for having me here. It's a great honor, ladies and gentlemen, to be in such a distinguished company. And even though I'm not genealogically allowed into this society, I salute you all for the good work that you do, and thank you for the invitation. I take as my text and begin with chapter 29 of the final version of Magna Carta of 1225, which reads as follows: "No free man shall be taken or imprisoned or be disseised of his freehold or liberties or free customs, but by lawful judgment of his peers and the law of the land. We will sell to no one, we will not deny or delay to anyone either right or justice." This is said to be one of only 3 parts of the Great Charter still in force in Great Britain, but this is rightly so because it's the heart and the soul of the statute. This text ensures that a person's property and body and reputation will not be taken away before and without a trial in a court of law in which the judge observes the law and the due process thereof. This requires hearing the evidence and the arguments of the parties, after which the judge applies the law to the facts of the case in order to reach a decision. This is the rule of law. This is the foundation of civilization. Consider the opposite of the rule of law. It's the rule of force. The rule of force is tyranny by the powerful, not by the just. It's where the big fish eat the little fish, and it is simply because they can. They have the power to do it. The rule of law is that right makes might. Without the rule of law, there can be no human rights. Human rights are the rights of an individual asserted against everyone else, if needed, such as the freedom of religion and the freedom of no religion. By contrast, if might makes right, society slips into anarchy as power moves from one person or group of persons to another. Anarchy is the opposite of freedom for these reasons. I hope that we can agree that anarchy is bad and that the rule of law is good. And I hope that we can agree that the rule of tyrants who are above the law is bad and the rule of law is good as well. So consider another opposite of the rule of law. It's the rule of no law, anarchy. Anarchy is where the tyrants who are the powerful, do whatever they please because they can. It's unpredictable, and of course, therefore, not even the tyrants are safe, because anarchy is the opposite of civilization. Now then, the rule of law requires access to the courts of law, and Section 29 of Magna Carta requires it. The courts enforce the rule of law by putting it into effect by their due process, that is, procedures for hearing the evidence and the arguments of the parties before it. The procedures of the courts is the skeleton of the substantive law, and the substance is the muscle of right. Now, the courts of law cannot function properly to administer the rule of law if they are not independent, and independent not only of the political branches of the government, but also independent of the will of the people. Human rights are not to be taken away by popular opinion or by votes. Human rights are often unpopular with the majority of the people as well as with tyrants. So a popular majority can act tyrannically and sometimes does. The independence of the judiciary can be destroyed by financial corruption, and it can be destroyed by political intimidation. Now, the focus then of the remainder of my remarks is the political control of judges. This is absolutely evil because it destroys the ability of the judges to administer the rule of law. Our federal and state constitutions all have checks and balances to prevent or at least minimize the political control of the judges. But most states provide for the popular election and re-election of the judiciary. And this power of control has no limitation whatsoever. The abuses come actually from the power to re-elect or not to re-elect a sitting judge. The power of popular election and re-election was not intended to oppress the judiciary or to manipulate the judiciary. The original idea was that as we have popular election of the executive branches, the executive branch and the legislative branch of the government, then why not have popular election of the judicial branch as well? And some people thought this was they thought that when this was getting started in the time of Jacksonian democracy, that in fact it would remove the judiciary from political control. However, the system worked in the past only because it wasn't followed. And it wasn't followed because in terms of re-election, it was a matter of courtesy, professional courtesy, that no one opposed a sitting judge for re-election. And so it worked because it didn't work. But the problem is that as time goes on, things change. And for the last 40 or 50 years, this custom, this convention is not being followed. And I think part of the reason for it is that judges are better paid than they used to be, so it's a nice job if you can get it. And if you can unsit a sitting judge in a re-election, then that's fair game. But the result is sad and shocking, and the result of the intimidation by the press and by the general public has been the result. If the judge's application of the law in a particular lawsuit will cost votes and result in not being re-elected, this strikes at the heart of the independence of the judiciary and thus the foundation of due process and the rule of law. And so here begins the epic catalog of examples of popular re-election of judges and why it's a bad thing. One of the most notorious examples of judicial intimidation by the press was the prosecution of Dr. Sam Shepard of Cleveland, Ohio, for the alleged murder, of his socialite wife. The judge in the case was due for imminent re-election, and the prosecutor was running for election to a different judgeship. Therefore, both needed the support of the press, and the press corps had decided that the defendant was guilty. And the United States, he was found guilty, and eventually the United States Supreme Court set aside the conviction because the public pressure of the press corps on the judge had denied the defendant his fundamental right of due process in an impartial court of law. Now, another example. A former student of mine who practices in Richmond recounted to me a while back that while he was trying a case in West Virginia, just a basic trial, during a recess, the bailiff came and said that the judge wished to see counsel in his chambers. And when they went to see the judge, he asked for a contribution to his re-election campaign. My friend refused to name the judge or say what he and opposing counsel did. But anyway, another student of mine from Texas, all of this is real, and this is why I'm giving this speech, because it's been sticking in my craw for many years. And I apologize for giving a political speech when you thought you were going to get an academic one. So another student of mine from Texas told me that her father was a trial court judge there. In one case, he ruled against a lawyer's motion in a completely routine case, a completely routine motion, but the lawyer went into a rage and started a campaign to defeat her father's re-election. The ground of the campaign against this judge was that he abused his children and he was soft on criminals. Oh. Well, his daughter, my student, said that he certainly was not abusive to his family, and she would know. And secondly, he didn't have any criminal jurisdiction anyway. And in fact, he was, in spite of the falsehoods, a very good judge, and he was not reelected. Now, closer to home, when driving through the state of Maryland, one sees these huge, expensive billboards urging the re-election of someone as judge of a particular court. And we know that the judge cannot afford to pay for the billboard, so then one wonders who did and why. And we'll never know. But the speculation does not lead to confidence in the judicial system of the state of Maryland, I'm sorry to say. There was a recent campaign for a judicial position in Maryland near the District of Columbia, and one of the candidates campaigned with the promise that if elected, she would impose the maximum sentence on every person convicted of drunk driving. So you can see who she's appealing to for votes. Now, a very distinguished judge from Northern Virginia opined in a presentation to one of the lunch meetings of the Richmond Bar Association that if this judicial candidate were elected, then she must recuse herself from every drunk driving case because she'd committed herself to the sentence before hearing the argument as to its appropriateness. So I do not know the outcome of the election because I don't know even who the judge was, or the candidate was, because that was left out of the speech. But the campaign promise itself impugns the integrity of the judicial process. What another example. All right, Justice Penny White, a member of the Supreme Court of Tennessee, ruled against the death penalty as applied in a particular case. Her position was highly unpopular with the law and order and the victims' rights elements of her state. They clearly did not understand the subtle distinctions of the law that Justice White was applying. And she was not reelected because of the legal position that she had taken, even though she was part of a majority of the court that found that particular way. Her decision and her opinion was entirely rational, and she was just the unlucky person whose term expired and had to come up for re-election next before things could get calmed down. So here are some random examples from Ohio, West Virginia, Texas, Maryland, Tennessee, and I'm sure that many others can be found elsewhere throughout the United States. The desire to influence the outcome of litigation in one's favor is, of course, only natural, and in fact, that's what lawyers are paid to do. It's the goal and purpose of every lawyer's argument in court. But this is done according to the due process of the court. But the attempt to influence the judge's decision not by argument and evidence presented in open court, but by an appeal to the judge's sympathy for an unfortunate person, or to corrupt the legal process by bribing him or her, or appealing to the fear of not being reelected, this is the problem. All judges will be tempted to unworthy behavior. After all, they live in the same world as the rest of us, and they should resist the temptation, and most of them do. But we need to make it as easy as possible for them to resist outside pressures in terms of deciding their opinions. And this should be done so that the fear that an upright and honest judge from an insecure system of judicial temper, it seems to me, requires the re-election of by a popular vote be changed. It interferes with the judge's application of the law and thus the rule of law itself. The problem is to find a workable way of protecting the good judges and removing the bad ones. The solution of the English and American federal system is to have the judges sit during good behavior, which means, in effect, for life, because it takes a judicial proceeding in a court of law to prove bad behavior. Virginia and a few other states protect sitting judges by having the periodic re-election done by the legislature, and this provides an effective shield against misdirected popular opinion. However, the popular vote for re-election of sitting judges is the norm for most state judiciaries. So the conclusion that comes to mind to correct this is to amend 39 state constitutions which require the popular re-election of judges, and to find another method of removing bad judges. While it may be unpalatable to the press corps, the politicians, petty tyrants, it's necessary to preserve the rule of law, which is the foundation of our liberty. And this is the requirement of the spirit of Magna Carta. Democracy, freedom, and the rule of law we have, more or less, but we need to make things better for ourselves and for our nation. We must strive for improvement. We cannot take for granted what we have. Thank you.
I'm going to be talking about the reason why Magna Carta has become much more vibrant in this country than in Great Britain. I'm sort of a student of English history as well as colonial American, and I find it very intriguing that the Americans have embedded Magna Carta and preserved it in a way that the country of its origin did not. So I will be talking a little bit about the difference between the two and how that happened. In 2005, I wrote an essay for the Social Affairs Unit in the UK, which was a sort of an online journal, entitled Farewell to Magna Carta. And at that point, there was a lot of concern in the UK because they had just passed the Prevention of Terrorism Bill, which included a long spell of preventive detention for suspects. Simon Jenkins, who was a journalist for The Guardian and the BBC, issued a plea pointing to Magna Carta and citing the right to a trial by peers and due process. Where, he pleaded, can liberty turn? And his answer was the House of Lords. Now, unfortunately, years before that, the House of Lords had been gutted by a simple majority of Parliament. And in 1999, the hereditary House of Lords, as you probably know, was abolished. So it's just all appointees now. The interesting thing I thought, apart from the fact that he could only advise returning to the House of Lords, who, by the way, do tend to uphold the rights more than one would expect, was that just a month earlier, this same Simon Jenkins had been pleading that juries should be abolished because they are a waste of time. And the fact is that, while we can be shocked at these comments, they could actually be done by Parliament. By a simple majority vote, Parliament can change the Constitution and abolish ancient rights. In 2003, Parliament had repealed the 800-year-old Prohibition against Double Jeopardy. All of you who are attorneys or schooled in the law will realize what a shock that was, certainly to us Americans. They repealed this prohibition against double jeopardy for murder, rape, manslaughter, kidnapping, drug trafficking, 20 other crimes, and then they made it retroactive for good measure. So presumably anyone who's been found innocent can always be retried if the new evidence is found. And in fact, the standard for new evidence was made lower than that for civil cases. The Attorney General at the time conceded that the debates that abolishing the prohibition against double jeopardy would uproot an ancient right, but he pointed out that does not necessarily mean it is a right for all time. I recognize the provision carries a price, but it's a price worth paying because of the justice it will bring about. The contrast with this is quite amazing. According to Google, there have been 11,539 amendments introduced to Congress to our Constitution. It's over 11,000. Since 1789, as you know, there have been only 27, and of course the first 10 were ratified in 1791. And 2 of the others had to do with temperance, and so one opposed it and the other expelled it. So here we have, these enormous number of amendments, and something like apparently 200 introduced every 2-year term of Congress. So clearly Magna Carta has remained important here. The Magna Carta is embedded in the state statute books of 17 of our states, the whole of it. 25 states have a due process provision in their constitution, and this provision is drawn from these chapters 39 and 40 of the 2015 text, that no person shall be deprived of life, liberty, or property without due process of law. The Supreme Court, although it doesn't cite Magna Carta often, has cited Magna Carta in over 200 cases, and it cited Magna Carta in the important Boumediene detainee case, Boumediene v. Bush in 2008. So why has this happened? Why have they been able to just change Magna Carta and even their constitution at will, and we have not? I think the timing is really important. When the colonists arrived here, there was a great deal of concern about individual rights in Great Britain in the 17th century, and of course they fought a civil war over that. So it was really at a height of the fear of royal power and its intrusion on individual rights. Sir Edward Coke, who was the most influential jurist in England at the time and in the American colonies, in the Institutes had a special essay about Magna Carta, emphasizing its restraint on Parliament. He praised Magna Carta for the great weightiness and weighty greatness, love that, great weightiness and weighty greatness of the matter contained, being the fountain of all the fundamental laws of the realm which make free men. He said, judgment given against any points of the Charter of Magna Carta or the Charter of the Force, which was passed at the same time, are adjudged void. If any statute be made against either of these charters, it shall be void. And to my mind, that is sort of the origins of our idea of judicial review, that something made against right is void. In Dr. Bonham's case in 1610, he also wrote, it appears in our books that in many cases the common law will control acts of Parliament and sometimes adjudge them to be utterly void. For when an act of Parliament is against common right and reason or repugnant or impossible to be performed, the common law will control it and adjudge it to be void. Unfortunately, elsewhere, in Cook's Institutes, he wrote that Parliament could not be confined either for causes or persons within any bounds. But our founders, Jefferson, Adams, Marshall, were all schooled on Cook's idea of Magna Carta and seemed not to pay too much attention to his comments about how Parliament could not be restrained. Their charter rights, beginning with the very first, as you probably know, with James I in 1606, included a clause that all of the colonists and every of their children which shall be born within any of the limits shall have and enjoy all liberties, franchises, and immunities as if they had been born and abiding in this our realm of England. And although there's this assumption that the colonists were really rather ignorant of the clauses of Magna Carta, and apparently weren't very many law books here, nonetheless, it's amazing how really keen and basic and thorough their understanding was, and they were very litigious and feisty right away. In 1646, the Massachusetts Bay Legislature issued a document comparing Magna Carta article by article with the fundamentals of Massachusetts and finding parallels throughout. Maryland in 1639, Massachusetts in 1641, what was called West New Jersey in 1676, passed statutes providing for common law and mentioned chapters of Magna Carta, especially these chapters 39 to 40 from the 1215 Charter. No free man shall be taken or imprisoned or dispossessed of his free tenement or liberties or free customs, or be outlawed or exiled or in any way destroyed. Nor will we condemn him, nor will we commit him to prison, excepting by legal judgment of his peers or by the law of the land. To none will we sell, to none will we deny, to none will we delay right or justice. In 1687, William Penn, the founder of Pennsylvania, actually had Magna Carta, the whole of the document, printed for the colonists, so that they would, as he put it, it was that this happy frame of government would shine most conspicuously in Pennsylvania. Particularly, he was concerned about representation in Parliament and juries. One of my favorite examples of Massachusetts in its height of litigiousness, I must tell you at length, so I hope you won't mind. But apparently in 1664, there was the Privy Council had complained that there was one of the laws passed by some of the colonies were repugnant to common law. The Massachusetts Bay Assembly, in a letter to their dread sovereign, took issue with a royal commission that accused the New England colonies of passing laws repugnant to the laws of England, claiming their own colony had, quote, an exemption to the payment of customs imposed by the Navigations Act. While other New England colonies yielded, the Massachusetts Bay Assembly reminded Charles II that their charter, reconfirmed by him just 2 years earlier, granted, quote, unto them their heirs, assigns, and associates forever, not only the absolute use and property of the tract of land herein mentioned, but the full and absolute power of governing all the people of this place by men chosen by themselves, and according to such laws as they shall from time to time see meet to make and establish, being not repugnant to the laws of England. And then they reminded him, and this I find amazing, that according to their charter, they were to pay only the 5th part of the ore of gold and silver that shall be therein found. And anyone who knows Massachusetts will know that, I mean, it's maybe in a jeweler's shop, but nowhere else are you likely to find gold and silver in respect of all the duties, demands, and exactions or services whatsoever. They even objected to the Royal Commission itself. We are like to be subjected to the arbitrary power of strangers, proceeding not by any established law, but by their own discretions. If these things go on, they warned, your subjects here will either be forced to seek new dwellings or sink and faint under the burdens that will be to them intolerable. The Crown officials were really cowed, apparently, by this, and they withdrew the commission. But the Massachusetts Assembly refused even to answer its charges. So that was Massachusetts in 1664. Why is Magna Carta entrenched here and not in the UK? I mentioned how important timing was for the feeling that Americans, or colonists had, that their rights were so terribly important. And at the time of the American Revolution, however, the English Constitution was shifting, and Parliament was now more and more sovereign. The Americans had absorbed this 17th century zeal for rights from Coke on Magna Carta, and they didn't trust to charters that were signed by kings or to Parliament, which had infringed on their rights. So they needed rights that were inalienable, that it didn't matter if the charters were taken away, it didn't have to depend on Parliament. In 1765, 10 years before the American Revolution, William Blackstone published his great work, The Commentaries on the Laws of England. And he wrote on individual rights and the power of Parliament. He believed that, he has a whole volume on the rights of persons, that the rights of individuals were, quote, vested in them by the immutable laws of nature, founded on nature and reason. They were not created by Magna Carta, which only protected and preserved them. However, Magna Carta, Blackstone wrote, protected every individual of the nation in the free enjoyment of his life, liberty, and property, unless declared to be forfeited by the judgment of his peers or the law of the land. He proclaimed every wanton and causeless restraint of the will of the subject, whether practiced by a monarch, a nobility, or a popular assembly, is a degree of tyranny. So why didn't they preserve Magna Carta? Well, Blackstone elsewhere famously wrote that Parliament can do anything that is not naturally impossible. The acts of Parliament that are impossible to be performed are of no validity, but if there arise out of them collaterally any absurd consequence, manifestly contradictory to common reason, they are, with regard to those collateral consequences, void. So anything Parliament wanted to do, they used to say Parliament could do anything but make a man a woman. And now I believe Parliament can do that as well. But at any rate, Blackstone, made these comments about how secure people's liberties were, but then Parliament had a right to do whatever it wanted, and presumably trusted that Parliament would never do anything to harm the people. In America, however, Jefferson and the Declaration of Independence inserted that all men were created equal and endowed by their creator with inalienable rights. And the first state constitutions that were passed had to be drawn up after that Declaration of Independence. Unlike the powers of the English Parliament that could alter or eliminate rights, these constitutions actually forbid their new legislatures from eliminating rights. So Delaware, for instance, in its constitution included, quote, the common law of England, as well as so much of the statute law that has been heretofore adopted in practice in this state, that shall remain in force unless they shall be altered by a future law of the legislature, except any laws repugnant to the rights and privileges contained in this Constitution and the Declaration of Rights. So their legislature could make any other laws, but they could not touch those laws that protected individual rights. New Jersey did the same thing. The common law of England, as well as so much of the statute law as have been heretofore practiced in this colony, shall still remain in force until they shall be altered by a future law of the legislature. Such parts only accepted as are repugnant to the rights and privileges contained in this charter, and that inestimable right of trial by jury shall remain confirmed as a part of the law of this colony without repeal forever. And Georgia said something very similar, claimed for the citizens' rights and privileges they are entitled to by the laws of nature and reason, Then they included several articles with a pledge, an English Bill of Rights, including forbidding excessive fines and bail, the right to habeas corpus, and to trial by jury, which was to remain inviolate forever. So U.S. constitutions actually embedded rights and amendments that comprise the Bill of Rights. And our Constitution is very, very difficult to amend. Unlike Parliament, which can by a simple majority vote change things, as you know, the Constitution has been very seldom amended, much to the annoyance of a lot of people, but that has really helped to preserve these basic rights. In conclusion, I would like to just read you a comment from the Federal Farmer, which was written during the debate over the ratification of the American Constitution in 1788. And the author explains how our freedom depends upon keeping in view that legacy of Magna Carta. He wrote that the people might not forget these rights and gradually become prepared for arbitrary government. Their discerning and honest leaders caused this instrument to be confirmed near 40 times, that's Magna Carta, and to be read twice a year in public places. Not that it would lose its validity without such confirmation, but to fix the content of it in the minds of the people as they successively come upon the stage. Men in some countries do not remain free merely because they are entitled to natural and inalienable rights. Men in all countries are entitled to them, not because their ancestors once got together and enumerated them on paper, but because by repeated enunciations and declarations, all parties are brought to realize them and, of course, to believe them to be sacred. I might show the wisdom of our past conduct as a people in not merely comforting ourselves that we were entitled to freedom, but in constantly keeping in view in addresses and bills of rights and newspapers the particular principles on which our freedom must always depend. Thank you.
Well, I have a rather mundane subject for you, but it's sort of the last right that you will have in your lifetime, and that is your will and to take care of your family. And there are a lot of rather technical provisions in Magna Carta that pertain to this, which I submit is the foundation of our modern decedent's estate law. So you're going to hear a lot of words that some of us remember from school and some of us never heard in the first place, but it's all part of the show. Anyway, we think of a decedent's estate today as a distinct entity from the decedent, his creditors, the creditors of the estate, the heirs, and the legatees. In fact, the decedent's estate has its own tax identification number, an EIN, and it is represented by the personal representative. But it was not always so. In the Middle Ages, there were three potential results from the death of a freeman: inheritance of feudal real estate by the heir, a partial recognition of a testate decedent's will with an intestate decedent, no will, various diversions of assets among sovereign, main lords, creditors, and families. Magna Carta contains arguably 16 chapters that bear on the decedent's estate. Before these provisions, King John rather regarded a decedent's estate, the inheritance of an underage heir in a wardship, as a form of a piggy bank. And the Magna Carta provisions were designed to restrain the urge to go to the piggy bank too often and too far. Magna Carta limits how much of the decedent's estate could be taken for crown debts, how much of a relief an heir should have to pay to succeed to a military tenancy, that no relief would be due on the cessation of a wardship, that a guardian should preserve the estate of a wardship for the ward, that widows should have limited indefeasible rights in their husbands' estates, should not be compelled to remarry, nor heirs be disparaged in their marriage, and that there was a limited right of testamentary freedom of disposition of personal property, and a protocol for the distribution of intestate's personal property on the suzerainty of the church. The liberties of the City of London were recognized, which arguably authorized the municipal boroughs to establish orphans' courts that handled estates of municipal freedom. Thus, what was recognized in this field in Magna Carta over the centuries evolved into our decedent's estate law of today, which recognizes an estate as a separate entity from the decedent, the creditors, the heirs, and the legatees, and provides for the orderly disposition of assets, payment of taxes and debts, the protection for the inheritance of minors and surviving spouses, and general testamentary freedom. How did this all happen? Since the time of Magna Carta, a little before, English decedent succession law distinguished between the descent of real property and the distribution of tangible personal property. Most real estate owned by a decedent descended to the eldest male heir. The King's Court condemned wills of land, except in Kent and Surrey boroughs, not because it interfered with military tenure, but because, as stated by Landville, now, although the general rule is that any person is allowed to give freely in his lifetime a reasonable part of his land to whomever he pleases, this liberty has not heretofore been extended to those about to die, because there might be an extravagant distribution of the inheritance if it were permitted to one who loses both memory and reason in the turmoil of his present suffering, a common enough happening. Therefore, if anyone mortally sick began to distribute his land, which he had not in the least wished to do while he was well, this would be presumed to result rather from turmoil of the spirit than from deliberation of the mind. Now, under feudalism, land was held in tenure. There was the tenure in chivalry, military tenure, consisting of knight service, grand sergeantry, petty sergeantry, non-military, considering a free socage and free farm, borough land held in burgage, and church land in Franklin. Military tenures carried with them certain feudal obligations, such as relief, a payment by the heir to succeed to his ancestors' land, feudal aid, such as the payment to the lord upon the knighting of the lord's first son, the marriage of his eldest daughter, payment of ransom for a captured lord. And if the tenant had no heir, the land would escheat back to the lord. The lord had a right of marriage, that is, to forbid the heir or heiress from marrying the lord's personal enemy, or the right to sell the right of the heir's marriage to the highest bidder. If the heir was a minor, the lord had a right of wardship until the heir became an adult, 21 for a male, 14 for a female if she married. McKechnie states about this, when the heir of a deceased tenant was unfitted to bear arms by reason of his tender years, the lands were, during his minority, without an effective owner. The lord treated them as temporarily escheated, entered into possession, drew the revenues, applied them to his own purposes, subject only to the obligation of maintaining the heir in a manner suited to his station in life. And lastly, the tenant owed the lord the tenant's personal military service for a specified number of nights and days in the field. In lieu of such service, scutage could be paid at the lord's election and sometimes at the tenant's. Tenants in grand sergeantry provided specific services, such as carrying a lance or banner or serving as the king's champion at the king's coronation. The guardian's rights in the person, in the marriage, and the lands of the heir are regarded as property. They are saleable, assignable rights. Large sums are paid for lordships and marriages of wealthy heirs. Indeed, so thoroughly proprietary and pecuniary are these rights that they can be disposed of by will, and they pass like chattels to the guardian's executors. Magna Carta addresses abuses and the feudal obligation involving military tenures. Chapter 2 addresses the relief to the heir who is an adult at the time of his ancestor's demise in order to succeed to his ancestor's tenure. The amount of relief was specified depending on the honor held by the heir, much like the schedule for loss of limbs under workers' compensation. Chapter 3 states that if the heir at the time is a minor, wardship shall be had, but not thereafter relief upon majority. Chapters 4 and 5 prescribe waste by the lord and a wardship and the converse duty to make the land productive. Chapters 6, 7, and 8 protect the heir by providing that the heir shall be married without disparagement. The widow may not be compelled to remarry. The widow may receive her dower without payment and remain in the residence for 40 days, a provision in the District of Columbia law only abolished in 2001. Free socage and fee farm were not subject to the feudal duties, as required only a periodic payment of money or agricultural supply. Burgage tenancy was also not the subject of these feudal obligations. When the freeman holding in socage or burgage died, there would be a guardianship of both land and child. But interestingly enough, the guardian had to be somebody who could not inherit. Fortescue in the 15th century had a nice description of this. The civil laws commit the guardianship of minors to the next in blood, whether agnates or cognates, that is, to each according to his degree and order in the succession to the ward's heritage. And the reason for this law is that no one will trouble to rear the minor more carefully and favorably than the next of blood. But the laws of England determine the guardianship of minors quite differently, where you cannot inherit, you're the guardian. And he says about the civil law, for these laws say to commit the care of a minor to him who is the next in succession to him is like committing the lamb to be devoured by the wolf. Magna Carta has two references to the distribution of personal property upon death, chapters 26 and chapters 27. Chapter 26 has rightly been given recognition to a customary right to make a will, a personal property of at least 1/3 after the payment of debts. While such a will had been recognized before 1215, the Church assumed the authority to handle wills, most likely as a result of the notion of the will as a form of last confession and opportunity to make bequests for pious causes. The wife's 1/3 and the children's 1/3, the legitimate, gradually faded from the scene in England until abolished in 1692. Coke, from you heard about earlier, said that this was never really the common law. But Bracton made a very interesting comment about it. Hence, as a matter of grace, children have no more rightful claim than wives, for a citizen would scarcely be found who would undertake a great enterprise in his lifetime if, at his death, he was compelled against his will to leave his estate to ignorant and extravagant children and undeserving wives. Thus, it is very necessary that freedom of action be given him in this respect, for thereby he will curb misconduct, encourage virtue, and put in the way of both wives and children an occasion for good behavior, which indeed might not come about if they knew without doubt that they would obtain a certain share irrespective of the testator's wishes. Recognition of the king's debts contained a limit. Only so much could be taken to cover the debt and not just a wholesale appropriation. I'm turning pages and not reading them in respect of our moderator's threat to cut us off at 20 minutes. Thus, what started out in chapter 26 permitted the growth of the law of decedents' estates under the jurisdiction of the ordinary, the bishop, the local diocese. But the church court had a limited jurisdiction, and suits on debts were undertaken in the common law courts, and legal issues were sent to chancery. The executor had nothing to do with real estate. There's a nice statement in a book from the 17th century. Though naming or appointing of an executor be essential to constitute a testament or last will, yet this properly refers only to goods and chattels, for a man may leave by his last will in writing, devise his lands, tenements, and hereditaments, though he make no executors, because an executor hath nothing to do with the freehold of land. You might be interested to know that the growth of the job of executor reached its zenith with John of Galt, who had no less than 17. Chapter 27 gave the church the right to oversee the distribution of an intestate's estate made by the nearest kinfolk and friends. The horror of intestacy increased at this time, and the church claimed the whole of the chattels of the intestate and the decedent's family and friends intended to be excluded. Chapter 27 seeks to save a part of the estate for the kin to distribute. Bracton said, if a free man dies intestate, and suddenly his lord shall in no wise meddle with his goods, save only to see after what belongs to him. That is, he to have his heriot, their administration will belong to the church and to his friends, for a man who dies intestate merits no punishment. Chapter 27 was deleted in the 1216 issue and never put back in. Why that is so is something of a mystery. And we don't need to solve why. One of the sidelights of feudalism concerns boroughs. It would appear that the king and his barons really did not much care what went on in boroughs so long as the boroughs produced money when it was needed. Thus, Chapter 13 provides that the city of London shall have its liberties and free customs. One of those customs involved the decedent's estate. The will of burgage land in the borough was proved not in the ecclesiastical court, but in the orphans' court. And here, as sanctioned by Magna Carta, develops a third source of our law. The orphans' court started in the 13th century and was providing largely for guardians. If you think about it, at those days you were much more likely to lose your parents. In these days, you're more likely to lose them from divorce, but then it was death. They had a very interesting way. They wanted to protect the inheritance, so they had a recognizance that would be recorded, that is like a bond, and you would have sureties on the bond, or you could deposit the money with the City of London and not have to put up the bond. And this continued for some time, and they developed a whole range of rules, but they didn't have the jurisdiction really to sue anybody quite the way we would assume today, so there was resort to chancery, that is the court of equity, and chancery kind of took over from the orphans' court by the 18th century. By 1600, on the eve of the colonization of America that was in place in England, primogeniture for military tenures with all the feudal incidents, wills for the portion of military tenures, and all for socage land, testaments for chattels administered under the church, and orphans' courts for the administration of estates of borough freemen, and guardians and socage, as they were called, and orphans' court for the preservation of a ward's estate. When the American colonies were first settled, two rather significant clauses were inserted in the charters, one granting the colonists the rights of Englishmen, as you previously heard, and the second granting land tenure and free and common socage. The effect of free and common socage was to preclude any tendency in chivalry with its relief, wardship, and marriage. Land was accordingly freely alienable and divisible. Some of the settlers were familiar with the various orphans' courts in the boroughs, and so orphans' courts appeared in Maryland, Delaware, New Jersey, North Carolina, later Pennsylvania. While primogeniture continued in many colonies until after the Revolution and real estate was not treated as an asset subject to administration by the executor, chancery courts were not present in the colonial period, so county courts and orphans' courts supervised administrations of estates. And the rules of guardianship were relaxed. Now a guardian could possibly inherit from a minor. Now, curiously, in the light of this history, we have a Supreme Court that is not doing its job. In 1898, the court, citing Blackstone, said, prior to the statute of wills enacted in the reign of Henry VIII, the right to a testimony disposition of the property did not extend to real estate at all, and as to the personal estate was limited. That's obviously not true, is it? Supreme Court of Wisconsin in 1906 said the right of testimony disposition of personal and real property, or at least a part of it, was recognized from the very earliest times. And then in a rather nasty comment, stated, the unanimity with which it is stated perhaps only equaled by the paucity of reasoning by which it is supported. In 1942, the Supreme Court again said, nothing in the federal Constitution forbids the legislature of a state to limit, condition, or even abolish the power of testimony disposition over property within its jurisdiction. And the rejoinder to that is, what happened to the Ninth Amendment? The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, you heard that I had a case in the Supreme Court. I cited Magna Carta. The Supreme Court didn't say anything about it. I discovered in the last couple of months that the Chief Justice said that anybody citing Magna Carta wouldn't get very far in the Supreme Court, and you can see from their stupid decisions why that is so. In reviewing the foregoing, one can see not only the effect of the Magna Carta to rein in King John's avarice, but also the effect to preserve the estate of the decedent for those ultimately entitled to it, namely the creditors, the widow, the heir, and the children. The death of a military tenant was no longer to be the opportunity to loot the tenant's estate in the name of feudal right, and testacy was no longer open season on the decedent's estate, and testimony freedom was largely established. Thus, the Magna Carta, do we look to the origin of an increasing disabled decedent's estate law and freedom of testation. So, I don't want you to enjoy that last right too soon, but just remember where it came from.
We certainly had an outstanding panel, and I thank them all very much for coming and for their contributions.